5, 4, 3, 2, 1. The AP High Court, relying on the decision of the Supreme Court in P. Sen versus State of Uttar Pradesh, held the inherent powers saved by Section 151 of the Code are, with respect to the procedure to be followed by the court in deciding the cause before it. These powers are not powers over the substantive rights which any litigant possesses. The AP High Court upheld the order of the court below in pointing that the endorsement of satisfaction was made by the plaintiff's advocate by a mistake, and that the power to recognize that mistake and restore the parties to their original position came within the scope of the inherent powers of the court, which must necessarily be exercised to achieve the ends of justice. In Ramesh Sen case, the petitioner filed a suit for money. The judge took the view that the matter should be referred to arbitration. Since the petitioner was not willing to go to arbitration, he filed an application to withdraw the suit. Thereafter, he filed an application under Section 151 CPC for withdrawal of the application for withdrawal of the suit. The Calcutta High Court held that if through a mistake the plaintiff had withdrawn the suit, the court was not powerless to allow him to withdraw the said withdrawal application in exercise of its inherent power. Of course, exercise of these powers by the court will always be for justifiable reasons. In this case, from a narration of facts that I have extracted above, it is obvious that in view of the fact that the parties were the same, and since the same counsel was dealing with both the suits, this mistake had arisen. The intention of the parties to prosecute OS number 2392 of 1992 is also apparent from the fact that they had filed an application to bring on record the legal representatives of the deceased first respondent. As regards the scope of Section 151 of the Code, courts have held that nothing can limit or affect the inherent power of the court to meet the ends of justice, and this is why courts recognized the inherent power, since it is not possible to foresee all the possible circumstances that may arise, not to provide for appropriate procedure to meet all those situations. In the instant case, if we deny the petitioner the right to rectify a genuine blunder which was committed, the cause of justice will suffer. The order of the court below is set aside. Both the CRPs are allowed. No costs. CMP 21113 of 1988 is closed. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.